All right, hello everyone. Welcome to week 14, and this is our last official full lecture of the class. So, congratulations, you've made it through the semester. Um, this week we're going to be touching on human rights violations in the criminal justice system, and I will give you a forewarning that this week is very critical of our criminal justice system, in the United States especially. Um, that's the purpose of this lecture. Um, we know, and I hope we know, that our criminal justice system is one of the best in the world. However, um, we're not perfect, and so this week is really going to highlight some of those imperfections in terms of human rights violations that our system perpetrates, um, as a system. And so, with that, I hope that you take notes, kind of listen and learn some things going through. This week is also different because you don't have like a chapter reading to do. However, you have several articles, websites, and handouts that I have provided to you in folio that I want to make sure that you look over and read. That is the material that you will need to kind of have read and kind of have a firm understanding for our quiz this week. All right, with that, let's go ahead and get started. So I want you to sit and think, um, what is the purpose of our criminal justice system? Why do we have a criminal justice system? Well, we talked about this a little bit when we talked about transitional justice and the purpose of justice. And a lot of you um, talked about how really the purpose should be uh, holding someone accountable. Well, there are actually five different punishment philosophies. So we know that our system um, inherently is set up to hold people who commit crimes accountable. So there are certain philosophies on how that punishment should be administered and what is the purpose of that punishment. Should it all be an eye for an eye, or should it all be rehabilitative? It really is a spectrum of philosophy. So the first punishment philosophy is known as deterrence. And the deterrence theory basically states that the purpose of punishment is to prevent future criminal behavior in both the individual that committed the behavior and in society as a whole, because they see that that person gets punished. And so, in essence, the deterrence theory states that the purpose of punishment is to deter future criminal behavior. Then you have retribution. And we talked a little bit about retributive justice last week, and it's the exact same thing. So, retribution as a punishment philosophy basically states that the purpose of punishment is to get even with the person who violated the law. They stole from us, so we need to take something from them, their freedom. Or they killed someone we love, therefore, the purpose of punishing them is to get even. That's retribution. Within retribution, you then have this component of incapacitation. And incapacitation as a punishment philosophy means that we take the offender out of the community and isolate them so that they can't offend again. And incapacitation is the root of our correctional, really kind of philosophy, uh, with your prisons and jails and things like that. So then you have this punishment philosophy of rehabilitation. So remember, we talked about rehabilitative justice, um, in terms of restorative justice last time. Restorative justice and rehabilitation punishment philosophy really are the same thing. So that rehabilitation sees that there is something missing in the offender, whether it be a lack of educational opportunities or a lack of social capital or a lack of opportunities, so that in turn they had to turn to a life of criminal behavior. And so the rehabilitative model basically um, says that the purpose of punishment, it recognizes the retribution aspect and the incapacitation aspect, but it also states that truly we need to rehabilitate the offender so that they don't have to turn to crime when they get out. And so, whether that mean giving them job skills or letting them get a GED or some educational attainment while they're incarcerated. And then finally, the final punishment philosophy is restoration. Um, and that is the purpose of punishment, is to um, restore the community back to pre-crime. It recognizes the victim. It really is that restorative justice mentality that we talked about last week. So those are your five punishment philosophies um, that permeate throughout our entire system of why we have a criminal justice system. Um, there's a general consensus that the purpose of this system is to hold those offenders accountable, and we do that through these five different punishment philosophies. These philosophies, no one philosophy is wrong or right. It typically operates on a continuum from all the way from retribution and incapacitation, deterrence, rehabilitation, and restoration. But it also didn't come to fruition on its own. So, what do I mean by that? Well, what how do we come up with these philosophies? It's important for us to understand that philosophies aren't willy-nilly notions that are just thrown out there. There's a lot of research and trend analysis and things like that that go into it. So, what makes up a punishment philosophy? Well, punishment philosophies are based on theories and empirical evidence. So, empirical evidence is research, and through research and empirical evidence, scholars theorize how our system acts. So, the theory itself is one of the five punishment philosophies. So, like retributive justice is a theory based on attitudes and notions and handlings of cases that scholars have analyzed through empirical evidence. But we also can't mitigate or downplay the effects of personal feelings that make up our punishment philosophies. So, we all look at criminal justice through a different lens. Some of us have been victims, some of us have been offenders, some of us have only studied victims and offender dynamics. But we all probably know someone who has been touched by some aspect of the criminal justice system. And so those personal feelings play a role combined with empirical evidence and theories to make up these punishment philosophies. So, a philosophy is not made up of just theory or just empirical evidence or just feelings. It's really made up of a combination of the three. So, we have certain safeguards built into our laws in the United States that are supposed to protect uh, us from violations of our civil liberties and civil rights. It hasn't always been that way, and as a society, we have grown to a facet to where when violations occur, we typically react with different laws and things like that. So, can you think of any laws in the United States that protect people involved in the criminal justice system? So, in my in person class, the way that we talk about this is what what is the supreme law of the land? If I was to ask you, what is the supreme law of the land? What do you think that would be? Well, if you answered the US Constitution, you would be right. Our Constitution is the foundation on which all of our laws are built. And in the Constitution, there are certain amendments um, that have been given to us to protect our rights. And so the first 10 amendments are known as the Bill of Rights. And in essence, your Bill of Rights can be broken down to different sections. And one of those sections within the Bill of Rights is your protections in the criminal justice system. So let's kind of go over some of these amendments. So the first amendment I want us to talk about is it's not on here, but so listen and take notes on this section. Let's talk about the Fourth Amendment. And the Fourth Amendment is the amendment that governs searches and seizures and warrants. And so the Fourth Amendment, in essence, states that the government can't come and search you just because they feel like it. There has to be this notion of probable cause, which is a standard of proof that has to be proven in order for them to be able to search you. Um, and it's supposed to protect our privacy rights. It also governs the notion of warrant. So when that probable cause standard is met, officers should be able to get warrants to search what they need to search. And so, because warrants or search and seizure can be very, like, you can have very minute details into the rights and liberties kind of associated with searches and seizures. Um, you have different types of warrants. And so you have announced warrants and you have no knock warrants. And the no knock warrants is where we typically get into our human rights violations and some of the civil liberty discussions around violations of human rights in our system. And we're going to talk about no knock warrants in a little bit. So then you have the Fifth Amendment, which is also not on this PowerPoint. Um, but the Fifth Amendment is our due process amendment, and it's probably one of my favorite amendments in our Bill of Rights and in our Constitution because due process, in essence, sets out how an individual should be treated in the system. And so, due process is the protections, um, both procedurally and substantively, in our system. That the rights that they have. And so procedural due process really is more about um, making sure that the system operations, this criminal justice system operations itself, does not violate any civil liberties of an individual. Substantive due process, in essence, there's many minute details to these two notions that you will get when you study criminal law or if you study a constitutional law class or something like that. But substantive due process is essentially um, your recognized rights as an individual living in this nation. And so this is your gray area, and is your substantive due rights is typically um, litigated a lot just to kind of bring some more clarity around that. So then you have the Sixth Amendment, and the Sixth Amendment deals with your jury trials. So you have the right to a jury trial, right to be judged by your peers. There should be no one person who is the judge, jury, and executioner. Our system is set up so that you have these safeguards in place because of your due process rights. But the Sixth Amendment also deals with something known as double jeopardy. And double jeopardy um, states that if you go out and commit a crime, you cannot be tried for the same crime dealing with the same situation twice unless there are certain kind of guidelines that um like if there's a mistrial or something like that, then you can, but you can't be found guilty of the same crime for the same situation twice. Then you have the Eighth Amendment, which is our bail amendment. And if you don't know what bail is essentially monetary payments that someone can make to get out of pretrial detention. So when someone's arrested, they're typically taken to jail and they're held pending a trial. And because of bail and the Eighth Amendment says that there should not be excessive bail. And we see a lot of controversy in our system now because there's an argument that bail inherently is discriminatory in its practice, especially cash bail, because who has $200,000 laying around that they can just give up? Um, Definitely not lower middle class, class socioeconomic um, individuals. And so I will say with the Eighth Amendment, make sure that you are aware there is not an inherent right to bail. An inherent right to bail is nowhere found in our Constitution. Instead, the Eighth Amendment states that if you're going to grant bail, bail cannot be excessive. It governs the excessiveness of bail. And then you have the 14th Amendment. And I have put this video, Amend the Fight for America. I don't have the full documentary, but it's the preview for the show that's on Netflix that covers the 14th Amendment. But in essence, the 14th Amendment is widely known as the Equal Protections Amendment. And so, in essence, the 14th Amendment addresses many aspects of citizenships and the rights of citizens in the United States. Um, and in essence, it that amendment provides that everyone in our nation should be under the umbrella of equal protections of the law under the Constitution. So make sure you check out that video. If you have Netflix, Amend is a great documentary. We will not be watching that in this class. Instead, we're going to be watching 13th this week uh, for our criminal justice violations. All right, so let's move on. So where do violations occur in our system? Where do these violations happen? Or where do we normally see these violations happen? Well, I can tell you human rights violations occurs in um every stage of the criminal justice system. So in your investigations, remember the Fourth Amendment with search and seizure. We see violations with search and seizure and no knock warrants. In arrest and pretrial detention, we see violations around extrajudicial killings and things like that that we'll talk about. Trials and sentencing, there's massive sentencing disparities, racial disparities in this system. You can pull up any type of academic research and find that those disparities are pretty well known. Um, Two people of a different race can be tried and convicted of the same crime, yet um, they can be sentenced differently. Most likely, if they're African American males, they get sentenced to longer sentences. Now, we have tried to correct that, um, and that has created its own ripple effect. But the sentencing guidelines were created in the 90s to kind of help um, mitigate's not the right word. Try to help alleviate some of those disparities. And the federal sentencing guidelines are not perfect by any means. However, they were an attempt to address those racial disparities. However, we still have some work to do. So, human rights violations occur in every facet and every stage of the criminal justice system. And there are many human rights issues in criminal justice systems globally. These are the ones that we're going to talk about this week. We're going to talk about extrajudicial killings and we're going to define extrajudicial killings. We're going to talk about torture. Do you think our system tortures individuals? Yes. The answer is yes. Um, we're going to talk about arbitrary detention and the death penalty. And I'm not going to um, I'm not going to focus too heavily on discrimination because discrimination permeates the other areas of human rights violations. However, I do want you to know that in the United States, some of the key issues are racial and ethnic disparities in police contact, arrest, convictions, and sentencing. In fact, you're going to watch a movie this week called 13th. And 13th is a historical documentary, a very powerful documentary on how the 13th Amendment was weaponized to continue slavery in the criminal justice system. It's a lot of um, it's heavy. I'll put it that way. It's heavy because if you have not been um, introduced to this concept, you come away with a different viewpoint. So I'm hoping that you guys will enjoy that video. I typically show it with American government and things like that, but it fits perfectly. So I wanted to give you the opportunity to view that. So you will see that in Folio, and that is one of the things that you do have to do this week is watch that. I think it's about a 2 hour documentary. But another argument in our system, as far as human rights violations go, besides the racial and ethnic disparity, is the overly punitive sentencing. So we talked about sentencing disparities. And in fact, racial disparities permeate throughout our system through sentencing disparities. In 13th, you're going to learn that 1 in 4 Black men will be incarcerated in their lifetime in our system. That is a proven statistic and it is astonishing, which means that someone watching this video knows or has been incarcerated themselves or knows someone who has been incarcerated. These violations touch us on a personal level in a lot of ways, yet we don't really stop and think about it. So these human rights violations up here are your main ones that we're going to talk about. So let's transition into another section of issues before we dive into those. Let's talk about women. Women issues are big issues in the criminal justice system. In fact, there are over 200,000 women incarcerated in U.S. prisons today. And one of the biggest human rights violations that we found is um, pregnant women. Now, we had this discussion in class, and I want you to kind of think about this discussion. When you're pregnant, you typically will need to have um, monthly check-ins with your doctor, prenatal care, kind of have some type of nutrition plan and things like that. Do you think women that are incarcerated get those luxuries? Do you think that they have proper checkups and proper prenatal care? Statistics and research, empirical evidence tells us no, that they do not. And that's a huge issue in our system. In fact, the birthing process itself is atrocious in many instances. So, a woman who is incarcerated is still considered a prisoner. And so when she goes into the hospital to have her baby, which, yes, um, many people who are pregnant go to hospital facilities to have their baby, um, they are chained and shackled. Um, they are a lot of times shackled to the bed. Then, when they have their baby, they don't get to spend a lot of time with their baby. Um, because they have to go back to jail once they're released. And so you have more prison programs that are kind of looking at maternal units and kind of seeing how they can increase the bonding opportunities and things like that. But it's still very restricted as far as that being one of the major women's issues in criminal justice is kind of pregnancy issues and kind of post pregnancy increased rates of postpartum and things like that. All right. So you have various videos that I have linked in Folio. Um, all of these videos are all under the material or the videos folder in Folio. Make sure you watch them. But now we're going to turn our attention to extrajudicial killings. And extrajudicial killings typically occur when a state actor murders someone before they have due process or a criminal trial. So, extrajudicial killings are really killings of suspected individuals before they have their due process rights and their right to a trial and before they're convicted. We see a lot of extrajudicial killings in two major scenarios that we'll talk about here in a minute. But make sure that you watch the video around some of the extrajudicial killings. Can you think of any extrajudicial killings that have happened recently? You have a video. Um, the Minneapolis police kill Amir Locke that I want you to watch. But I also have George Floyd and Breonna Taylor videos up that I want you to watch. So, the way that we normally see extrajudicial killings in the United States is through police use of force or excessive use of force and no knock warrants. So, in terms of George Floyd, back in 2020, George Floyd was murdered on the streets by a police officer kneeling on his neck, cutting off his ability to breathe. Um, all while he was still being arrested. He had not gone to court, not been tried and convicted. He was still accused at that point. Um, that is excessive use of force. And I brought this up in class. Statistics can be kind of um, staggering as far as there's been an explosion in police use of force since 2020. However, the numbers are very small. So I think there's only been like 1,200 police killings uh, over the past year. However, that number is up from last year. So when we talk about police interactions, there are millions of interactions daily that police have with individuals across the United States. However, we typically focus on those that go wrong. Um, and although those numbers are low, they do show some empirical evidence of potential biases and things like that through use of force data. Now, another form of extrajudicial killing is known as no knock warrants. And this is where Breonna Taylor's story happened. Breonna Taylor also happened in 2020, and police were serving a no knock warrant. And remember, a no knock warrant is a warrant that police can use. It's signed by a judge, but they don't have to announce themselves. They just go into the residence with the force. You will watch the video on some of the controversies. I think there's two videos I have on the controversies around no knock warrants. Make sure you pay attention to those. All right. So now let's turn our attention to talking about some torture in the United States. So when we're talking about torture, I'm specifically going to address torture through the use of solitary confinement. So solitary confinement is um, a type in which the inmate is physically, visibly, and audibly confined. Solitary confinement is typically overused or misused, and you'll hear solitary confinement called different things. So you may hear solitary confinement called ag-seg, segregation, or the hole. Um, it's usually individuals who are under protective custody or there's some risk to their safety that are kept ongoing in solitary confinement. Solitary confinement is also utilized as a punishment in the prison. But you really kind of see those violations with solitary confinement in that ongoing population that where prisons use solitary confinement for prisoners' own personal safety. We do see LGBTQ plus inmates being put in solitary confinement more because they're put there for their own personal safety. So there are approximately 60,000 to 80,000 inmates in solitary confinement. And that's approximately 4.4% of the state and federal inmates. So approximately 4%, give or take, between 4 and 5% of federal and state inmates are kept in solitary confinement. It's a huge number. And why should we care? Well, let's go to the next slide. Solitary confinement, as I stated, has vast emotional and psychological damages on individuals who are kept there in an ongoing basis. Think about it. If you were cut off from your friends, family, and any social interactions for 23 hours a day, they typically get 1 hour where they get to go out on the yard. Um, but that's going to cause some significant psychological effects. And we see that a lot with 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 solitary confinement. And so in terms of torture, we typically will associate solitary confinement to torture because of the psychological damages that it does on the individuals that undergo it. All right, so now let's go to the next section. So, our next type of violation that we're going to talk about is arbitrary detention. And arbitrary detention is unlawful detention that occurs when someone is arrested or detained by a government without due process, without a fair trial, and without any legal basis for that deprivation. And so you're going to watch a video on Khalif Browder. And I want you to pay attention because Khalif Browder's story is not an unusual story in our system. Khalif Browder was detained and kept in detention for months without ever having a trial. He is um, a prime example of arbitrary detention. And why does this happen? Well, as you will remember, Fourth Amendment search and seizure protections are supposed to be in place. However, over the last century or so, our Supreme Court has relaxed. Well, that's too general. There was a time where the Supreme Court had relaxed search and seizure processes. And so there was a time where the court recognized that officers have specialized experience, and because of that experience, they could rely on their gut feelings to detain someone and search them. And we've kind of tightened up a little bit on that. We still have a ways to go. Um, but New York was a prime example of that several years ago, where they had a policy of free detention. And basically, what I mean by that is um, cops would walk the streets, and if they felt you looked suspicious, they could freely detain you and question you. Now that led to a lot of racial discrimination and kind of highlighted the racial bias that permeates throughout our system, and still does. But those forms of arbitrary detention happen on a daily basis. So make sure you check out Khalif Browder's story. All right. So let's turn our attention to the death penalty. And there's going to be several videos again that are in the video section that I want you to watch. But the death penalty is a highly, highly controversial topic in criminal justice. Um, Internationally, there have been calls for the abolition of the death penalty. And in fact, 108 countries have banned the death penalty, but 55 maintain it in their laws. And in the United States, we still maintain the death penalty in our laws. You have in your materials section, you have a link to 2023 statistics um, around the death penalty, and kind of can look at some charts and visuals around the death penalty. We have seen death penalty use decline since the 50s. However, it is still a viable option in several states. Now, we do have, I think, probably around 23 states that have outlawed the death penalty, but the majority of our states still utilize the death penalty or have death penalty laws on the books. And there are many methods of execution. So, there are most common that you probably heard of are electric chairs or lethal injections. But there are um, death penalty. Um, what is the word that I'm looking for? There are methods, death penalty methods, that utilize firing squads where they march the prisoner out and the officers are there lined up and they shoot them. Like all the officers fire at a certain time and shoot the prisoner. We have seen in our history hangings. Hangings can still be utilized. They're not utilized a lot in our country, but you do see hangings being utilized as a death penalty option throughout much of the world. And then beheadings. So, as I stated, the death penalty is extremely controversial. And there is a pro death penalty movement and an anti death penalty movement. And so let's kind of talk about why is there a movement to preserve the death penalty? Well, that goes back to those punishment philosophies that we talked about at the beginning of this lecture. We know that our system is highly retribution based. And so because we see the purpose of this system as a means to punish behavior, um, death penalty is the ultimate punishment for those who kill. And so, at the essence of the pro death penalty conversations, we see that retribution is the foundation for their arguments. We also see that they argue that there's a deterrence effect. If someone, if society sees that a murderer will be put to death, then there's less likely people who will turn to that form of crime. Um, Death penalties are typically done in capital cases in the United States, um, and are treated very differently as far as jury selection and prosecution. So, because they are deal with so severe circumstances. There is a thought that the people who are up for the death penalty are probably our most heinous criminals. There's an inherent public safety argument that states these people have to be put to death for the safety of everyone else because they can never be free individuals again. And then finally, we see pro death penalty arguments um, that are formed around this notion of closure and justice. So last week we talked about what is justice and kind of had you see the different mentalities around how is justice truly defined and how is justice really served. Well, pro death penalty arguments um, argue that the only type of true justice in death penalty cases or these capital cases like murder and things like that, um, the only true type of justice and the only true type of closure that the victims can have is to see that offender die. And so um, you have, again, I would argue that goes back to our um, retribution mindset. And so these are your main four arguments for the death penalty. Now, let's look at your arguments against the death penalty. Well, I hope you take an opportunity. You should be, it is a required document, to look at the 2023 statistics around the death penalty. It's a United States focused paper. You will notice that an average of about 3.9% of people sitting on death row are exonerated per year. That's a staggering statistic. 3.9 people that are currently sitting on death row are exonerated of their crimes. So inherently, we have this argument that death is final. Death is your final resolution. But mistakes happen and innocent people are executed. There's no way of getting around that. Probably one of our biggest human rights violations in our system is execution of the innocents in terms and in our bloodthirst. Statistics have proven, and you have them in front of you, that there are procedural errors that happen in these cases that cause innocent people to go to prison and sit on death row and ultimately become executed. And so the biggest argument against the death penalty is if one life is mistakenly put to death, then we are no better than a regular murderer, because a regular murderer killed an innocent person. And in essence, we do the same. So you saw that the pro death penalty argument talked about deterrence and how um, there's this deterrence factor, um, that keep people from committing those type of offenses because they see that the death penalty is the ultimate option for punishment. Well, empirical evidence has shown us that um, the death penalty is not effective in deterrence. Um, there are many factors that go into the criminal committing the crime, and deterrence is not one of them. The death penalty is extremely expensive, um, and is extremely discriminatory. And you're going to see some statistics around, like, the majority of people sitting on death row are white male individuals, which is what you probably wouldn't think. However, we have seen that those that are actually put to death typically are your minorities. And so there's an extremely discriminatory undertone to the death penalty itself and the use of the death penalty. So, what do we do about these violations? Well, your generation is the generation that has raised the most concern in recent memory. And I say we continue doing that. We have to raise awareness of what's happening in these systems globally. I did not take a global approach to this lecture. I focused on the United States specifically, but I would encourage you to take a comparative criminal justice systems class, um, and kind of see. Uh, we do not have it as bad as some. There are some who don't have trials, who one person plays judge, jury, executioner, who are extremely retributive minded, and things like that. So while our system is flawed, no system is perfect. Our system is far better than a lot worldwide. Um, we have to inform the public of laws, rights, and resources. And we have to advocate that our constitutional rights not be violated and call out when those things happen. Um, Knowledge is power, and I think that's one of my favorite things about this class is, I know when I was an undergrad, I didn't have a class like this that was offered around human rights violations and things like that. So one of the exciting things about teaching a class like this is to bring awareness to something that you may not have ever focused on in your educational journey. And our system has a lot of work to do, and you guys are going to be the ones leading the way in that work. All right. So that's going to conclude our lecture this week, which, congratulations, this is the last lecture of the class. Week after next is our Thanksgiving break, and then you come back and you'll have a week to work on your papers, and then we'll go into finals. So I just want to say thank you to all of you for being a great class, and for being patient with me, and just for kind of the value that you brought to this class. Learned a lot from each of you, and I hope you guys have learned a lot through our time together. As you will see, you have the regular week 14 quiz, but then you have another quiz called the SLO quiz. That quiz is not graded. It is strictly a quiz that I need you to take that kind of shows what all you've learned, and if I've hit my mark as your instructor for your learning outcomes. Um, those that do complete it will get 3 additional bonus points added to their final exam score. Whatever they score, they'll get 3 additional points added to that. So, as always, if you need anything, feel free to reach out to me. I hope you all have a great week, and I will see you later.